Florida attorney L. Reed Bloodworth is the managing partner of Bloodworth Law. The Orlando and Winter Haven law firm handles employment litigation for Florida employers facing federal and state legal disputes with employees on a range of issues. Employment litigation attorney and Bloodworth Law partner J. Kemp Brinson explains that federal laws protect the rights of LGBTQ+ employees. In Florida, there are no state statutes that specifically give LGBTQ+ employees rights any different than the rights that are guaranteed and made available under federal law, Kemp said. There are a few municipalities and counties within Florida that have their own regulations, but in terms of statewide rights, this is governed primarily by federal law and by state law that is influenced by that federal law. Kemp said that this is really a federal right, as opposed to a specifically Florida right. So under some recent Supreme Court precedents, both the issue of gender identity as well as the issue of sexual orientation are considered essentially baked into the term sex. The federal statute prohibits discrimination on the basis of sex, and the Supreme Court has determined that the phrase "on the basis of sex" essentially means also on the basis of sexual orientation or gender identity. Kemp explained that if someone is treated differently because of their sexual orientation or because of their gender identity, that person has been discriminated against on the basis of sex, as prohibited by federal and state law. That could take the form of straightforward discrimination, Kemp said. For example, blatantly adverse treatment of people based on their sexual orientation or gender identity. Or it could take the form of more subtle forms of discrimination, such as sex-specific dress codes and sex-specific stereotyping. Kemp explained that saying things like, "You're not acting like a man," or "You're not acting like a woman," or "You're not acting ladylike," is stereotyping, because those terms don't mean anything actual other than the former cultural significance that was attached to them. And the idea is that someone whose gender or sexual orientation doesn't conform with what society might think of as, quote, male or female, when or if that person is treated differently based on that presumption or any assumption about who they are, that is a form of sex discrimination, Kemp said. Employers are governed by federal and Florida employment laws that affect their companies and employees. The Bloodworth Law employment team notes that every discrimination claim is different. Case details are unique, so you can't read online or use comments made in this video, for example, and attach it to your employee situation. To clarify discrimination, harassment, or other employment laws, talk with Reed, Kemp, and the employment law team to find out how Bloodworth Law can help you, your employees, or your business.